Welcome to Bracewell. Thank you very much for joining us today. In addition to the people that we have here in our Houston office, we have also people joining in other of our offices and also by webinars. So again, thank you very much for joining us in this Mexico oil and gas presentation, and I hope that you enjoy it. My name is Manuel Vera. I'm a partner here in the Houston office. I'm a Mexican lawyer. I was born and raised in Mexico City. I worked there in a law firm for a few years, and then I moved to Houston and joined Bracewell 18 years ago, so I've been here for a while. I'm a corporate energy and finance lawyer, and my main practice is to help our clients with their business or their projects in these areas in Latin America, but with more emphasis, of course, in Mexico. So let me introduce our panel. I'm going to go started with my next right. First, we have from Mexico City our good friend Manuel Cervantes. Manuel Cervantes is the managing director of MCM Abogados. It's a Mexican law firm deeply involved in the oil and gas sector in Mexico. Manuel has advised companies in performance and JV-related matters in more than 15% of the total E&P contract that has been awarded under the current energy reform. So he's very active in Mexico with all these new contracts. Then we have my partner in London, Darren Spalding. Darren is an oil and gas lawyer, again based in our London office. He works on M&A transactions and projects globally and has been involved in five deals in Mexico over the last 12 months. Then we have my partner Blythe from our London office also. Adam works on M&A joint ventures and project development in the petroleum sector. He has a lot of experience in international projects and has recently advised on 3 upstream deals in Mexico. And then we have Jeffery Vaden. Jeff is also a partner here in the Houston office. He's a white-collar defense and investigation lawyer. He's a former federal prosecutor and has represented companies and individuals in FCPA matters, an internal investigation involving Mexico, Canada, South Africa, Iraq, Equatorial Guinea, Indonesia, and other countries. So we're going to the presentation. We have an agenda with several items to discuss. We're going to start first with a brief introduction of the energy reform. I'm sure that most of you are familiar with the reform and what happened, so we will be very brief. Then we will discuss the political landscape and the state of play. Then we will talk about the deal doing in Mexico, overview of recent deal activities, regulatory matters, and differences between PSA contracts in the US and the UK. Then we briefly discuss about financing, acquisition, and financing of projects in Mexico. And then Jeff is going to make a presentation about anti-corruption enforcement in the US and Mexico. And finally, we will discuss what's next in Mexico, what's our thoughts about what's going on, where are we going. We will have a panel discussions with some questions among ourselves. And we will close the program with a Q&A session. So if you have any questions, please hold, and we will be happy to answer all the questions that you have at the end of the program. Okay, so we wanted to start the presentation with this map, which we think is an eye-opening map. Well, during the presentation, we're going to say some maybe not that positive things about Mexico, what's going on, others positive, we believe. But I think this map shows the potential, and this is upstream only, but this is the potential of Mexico for upstream activity. So we can see, obviously, the Gulf of Mexico divided in the north part, U.S. waters, and then the south part, Mexico waters. And you will see the thousands of oil blocks in the U.S. side, the green dots. And then you will see in the south part of the Gulf, very few orange dots, which are the blocks currently under exploration or extraction in the Mexico side. Most of the activity, as you can see, are in the south of the country, in the states of Tabasco, Veracruz, and Campeche, and some in the north, which actually are some of the few blocks that have been awarded for deep water. And we can show you similar maps for power or for midstream if we compare the pipeline system of Mexico against the United States or or the power grid of Mexico and the United States. Obviously, the difference is huge. So again, the potential that we see in Mexico is huge. The oil is there. The Mexican government through Pemex, they don't have all the capacity, the technical and financial capacity they need in order to be able to explore and extract the oil there. Mexico is a country with a population higher than 120 million and growing. So again, the future of the energy in Mexico is just going to increase. So again, we want to briefly discuss what happened with energy reform and some of the activities or some of the things that have changed in Mexico as a result of the end of the reform. And again, I'm sure that a lot of you are already familiar with this, but before December 2013, the Mexican Constitution was amended in order to allow private investment in pretty much all the energy sector. Before that, all the oil and gas industry was pretty much monopolized by Pemex, and then the power industry was monopolized by the CFE, or the Mexican Electricity Commission. Except for a few industries like midstream pipelines or power, that some type of a structure with private investment was permitted. So in 2013, the amendment of the Constitution, the Constitution is amended, and an array of laws, regulations, and hundreds of rules were issued in order to place or to put together the energy reform in the upstream, midstream, downstream, and the power sector. For the upstream, the main activity that was open was the possibility for companies, private companies, including international companies, through the formation of Mexican subsidiaries, to enter into exploration and extraction contracts, mainly in the Gulf of Mexico. And the way it worked was it was divided in rounds with bids for these contracts. There were a total of 3 bids, or 3 rounds, excuse me. The first round and the second round, each one has 4 stages. The first round was 1.1, which has shallow waters, and then went to 1.1, 1.2, 1.3, 1.4, and so forth. The 1.4 was the first bid for deep water, which I believe was quite success for the Mexican government. The third round, it was only the third round is 3.1 only. 3.2 and 3.3 has been suspended for now. But in general terms, we believe that it was a successful process. In total, 111 contracts have been entered between private companies and the Mexican government through the Mexican Hydrocarbon Commissions, or the CNH. From these 111 contracts are executed by 75 companies coming from 20 different countries all over the world. So again, it was there's a lot of investment, a lot of resources that have been compromised for the development of all these blocks that were offered in these rounds. Talking briefly about midstream, and well, there's just the map that shows the countries that have all the countries that have the companies that have entered into agreement with the CNH, the number of contracts, the blocks that have been given were auctioned and awarded to the private companies. Then midstream and downstream. Midstream and downstream were almost completely open with the energy reform. As I mentioned, the midstream industry, at least the pipeline system, was already open in certain structure, allowing some type of private investment. But this is similar to the map that I showed you, the first bullet point. Is also to give you an example of the potential in Mexico. As of November 2018, Mexico had a pipeline system of 9,900 miles. On November, that same month, the government reported that there's additional 1,700 miles under construction. So the total is like 11,000 miles for Mexico. If you put that in context, comparing just to Texas, not the United States, but just Texas, Texas has a pipeline system of 106,000 miles for natural gas distribution and a total of 228,000 miles. So the whole country of Mexico has like 5% of the pipelines that Texas has. I'm not saying that Mexico needs so many miles, but again, there's a lot of need of continued investment of pipelines to connect the country. I think mainly in the center of the country where there's really a dire need of a bigger pipeline system or infrastructure. Then we have the refineries. Currently, we have 6 refineries in Mexico. Some of them are in very poor condition. Some of them are underperforming. I don't think that any refinery is operating at 100% right now. Some of them are actually operating at 20, 30%. So there's something that obviously we need to consider as to potential investment, which led me to the next bullet point, and one of the most aggressive projects of this administration, which is the announcement of the construction of a new refinery in Dos Bocas, Tabasco, which Tabasco is one of the states of the South. This is a tremendous project announced by the government last week, and we will discuss in detail this project. I think this project, together with what is called the Tren Maya, which is a train that they plan to build through the Yucatan Peninsula, are the 2 flagship projects for this administration. If you've been in Mexico a few years ago, or you visited Mexico a few years ago, you may have noticed that all the gas stations were Pemex. So if you want to put gas in your car, it was Pemex, and with the same fixed price for all the stations. And if you've been in Mexico lately, you will notice that now you have, in addition to the Pemex gas stations, you have plenty of other new stations under different brands, some Mexican brands, but also some of the international players. So if you go, you can see gas stations with BP, Shell, Total, Exxon, etc. So there's a big investment also in the gasoline market that has been completely open, and now actually the gas stations can offer different prices. There's still some restrictions, of course, as to prices, but that's something else that has been completely open. There's other potential or possibilities or opportunities in Mexico, the upstream or the midstream, and downstream area. And there's several new storage terminals in Mexican ports are under construction, but a lot of infrastructure is going to be needed around these terminals. There's the possibility to construct new or to improve current LNG import terminals. Actually, there's a very aggressive plan to develop one that is already constructed owned by Sempra and Yenova, and they have these big expansion plans for this LNG terminal. And finally, something that is going to increase also is the FPSOs, or floating production storage and offloading, that the units. That in the future we will see more also as a result of the need of this type of units in the Gulf of Mexico. Now we will move to the next presentation or section that will be the political landscape and state of play, that will be presented by Manuel Cervantes.
Thank you, Manuel. Can you hear me? Thanks. Well, to talk about this topic, we might need, if not hours, probably days, to do an analysis of what's going on in Mexico. The scenario has substantially changed, and that's a reality. So we try to simplify some ideas in this slide and in the next one about some relevant aspects that have an impact in our industry. It's important to understand that the new administration de facto took control since the same day of the elections. I mean, we're talking about a government that has been expressing and explaining their concept of nation since July last year. From the very beginning, they have established the main targets, principles around their plan of nation. And one fundamental tool that the government has implemented is on a daily basis. Every day, our president has a conference with the press that is broadcasted, is in the national media, that may take from 1 to 2 hours with a well-defined structure to how to conduct this conference. In that conference, he explains his actions, strategies. He also make an analysis from the ideology-ethical point of view of what he's expecting that country to behave from now on. And that's also very important. Has a strong message of ideology in these conferences. The other point is that he has made emphasis in the comparison with the old regime in all senses. Corruption, anti-corruption is a core principle that is mentioned every single day. One of the critics about these conferences and this mechanism is that sometimes they come up with ideas, new ideas and occurrences that sometimes don't have a well-defined plan or strategy or an analysis of consequences. And this has been seen in few decisions already taken that are known, I think, by all of us, like cancellation of the airport, his open disagreement with some of the relevant regulatory institutions that are autonomous in our country, like the CNH or the CREs, the Antitrust Commission as well, that are institutions in Mexico that counterbalance the decisions of the government in all these relevant topics. This mechanic, this way of doing politics and way of taking decisions has created sometimes contradictions between different departments and public officers of the new administration. And it happens, and it's actually shown in TV, sometimes these contradictions. One example was precisely about the refinery. The same day that one of the senior officers was explaining, I think in London, about government was having second thoughts about doing that in the short term and use that money to improve Pemex position given the reaction that the rating agencies and investors had with a pure plan for Pemex. That same day, Mexico time, Mexico hour, in this conference, the president said, no, listen, probably there was some misunderstanding or miscommunication by my subordinate, but this project is going. So that's the type of dynamic that we are facing now. What is very important is to monitor and follow what our president is establishing as the national agenda on a daily basis. Talking about fighting against corruption, it's a core principle as explained, but there are some critics now about the lack of implementation that can be measured objectively. At the same time, the term corruption has been somehow expanded as to its definition to consider other things that are not corruption, like the previous regime, neoliberalism, that somehow are considered by the new administration as equivalent to corruption. The other is that somehow the new administration is awarding projects based on direct assignment without going through a public bid in a process that is not entirely transparent or the rules are not in the way that we have seen, for example, if compared with CNH procedures. And that's one of the main critics now. I mean, 76% of the procurement is done through direct assignment. And the other is he's increasing there's a period in which former government officers cannot work for the industry because of conflict of interest. That's the normal rule worldwide. And in Mexico, so far is a ban period of 1 year, which is very standard and normal. Our president is now considering to increase that period of impossibility to work for the industry to 10 years. And that's something that has created a lot of strong messages to the industry in general. Now, talking specifically about the new energy agenda, he has clear that production must be increased. And all the faith of the new government is on Pemex. And Pemex is keeping entitlements. They are receiving much more budget. They will do considerably higher investment if compared to previous years. But this is still short. The plan is still short. They are saying, for example, that Pemex will be granted some special tax treatment to be able to make more tax deductions. But the details of those plans have not been released yet. I mean, the idea was informed weeks ago, and we are still waiting to check the details because devil is on the details. And it's not the first time that Pemex receives some incentives with decrees by the Mexican finance to make more deductions. So let's see where's the novelty on that, no? There is a bill of reform. He has strongly explained that fracking is not going to be allowed in Mexico. Some people of his own government have expressed that that's not exactly the case. Perhaps yes, perhaps not. At least in this morning conference, he has said that it will be prohibited. The bill is there, is at Congress, has not been discussed or approved yet. But if that happens, that may significantly impact the possibility to develop non-conventionals and also conventionals where Pemex have been doing fracking for decades. The first well with fracking in Mexico was in '96. So, I mean, it's something that is really not new. But he has that potential target. Strengthening Pemex has been focused more on shallow waters and onshore projects, gas projects located in Tabasco. We're just talking about 20 fields that will have most of the attention and investment for the next 3 years. But what about that map that Manuel Vera explained us about all that potential deep water, shallow water in other regions and non-conventionals? Something needs to do that, right? So part of our forecast, or my forecast, is that a lot of targets were established by López Obrador for the first 3 years or by the end of his period, and some of them might be unachievable from the practical point of view. The refinery has a very aggressive target. He says 3 years, no? Investing 2.5 billion. There's people saying that it's going to be twice funds and twice time. And that will put a lot of pressure on him. Also, Pemex, with all these 20 fields, it's difficult that they can reach the production objectives they have to increase to 2.6 million barrels per day when we are in a frank declination and sustained decrease. We are now around 1.7, close to 1.7. So Pemex cannot do that itself in the short term. So then we expect that he realizes that he needs to retake the bidding procedures. He needs to entice and put more effort on the private operators that are working now, which, by the way, several of those projects will have important investment in exploration stage with committed wells, exploration wells, delimitation wells. Some are close to jump to production with field development plans approved that potentially will increase in 3-4 years, close to 300,000 barrels. So we will talk a little bit more in the presentation about what's going on and if liberalization is really indeed on hold or what's coming. Yeah. And for our next topic, Darren, you're going to explain about deal doing in Mexico, no?
Yeah, actually, Adam is going to start with the presentation, and then Darren. Yeah.
Sorry.
Okay. Thanks. So in this section, and thanks for that context, Manuel, as to the political landscape, we're now going to look at what that means for actual deal doing in Mexico and some of the first deals that we've seen in the upstream sector over the past year. So we'll look at that recent deal activity and what we can learn from that. We'll also quickly run through some of the fundamentals behind the Mexican regime and what impacts that has on deal doing and considerations you need to have in mind for your deal process. And then Darren will come on to look at some of the particular issues and challenges that we've come up against in our experience of doing deals in Mexico. I think just to set a few sort of frameworks around what we're going to talk about. So we're going to concentrate on the upstream in this particular section. That's because there's a very special regime that applies to the upstream, and that's what we've been working on and what we'll talk about. Secondly, when we talk about deal doing, we mean the transfer of an interest in an upstream concession. So in the Mexican regime, and the same for much of the non-US approach to doing upstream concessions, what we have is the government granting a concession to private companies to go for a particular contract area to explore and win production. And it's your interest in that concession contract, which is the subject. We're talking about the secondary transfer. So following its award to a company, what can they do to transfer that interest? And likewise, what can an incoming party do to acquire an interest in that? And then if you're slightly puzzled as to why a British voice is speaking today to you in Houston about these matters, and you've got an even stranger accent to follow, I'm afraid, that is because much of these early deals that have been done are being done subject to a combination of Mexican law and English law. So you have Mexican law governing these concessions and many of the underlying contracts, and also important in the transfer process, many of the documents you need to sign. But what we've seen in our experience is English law is commonly being used for the actual purchase and sale agreement. And that seems to be the kind of market choice as a neutral, well-recognized and independent choice of law option. So you may get used to hearing our funny voices, I'm afraid. So just to take a look at what has been the recent deal activity, on the slide, you'll see all of the upstream deals that have happened last year, and that represents the entirety of all private A&D work in the upstream world in Mexico. What do they show us? What can we learn from this? Well, I think firstly, and perhaps most obviously, is that deals are now being done. So it's taken a while since liberalization for there actually to be private A&D transactions, but last year saw a spate of them. So it's important and helpful to recognize that companies have been able to reach agreement on sensible terms and are prepared to do deals. It's also important to recognize, notwithstanding some of the breaks and pauses on liberalization and the award process of new licenses, the Mexican government and regulators are engaging with these private deals, and they are giving the necessary consents to allow them to happen. So that pause, potential pause on liberalization, is not stopping private A&D activity. I think the other trends we can pick out from this, clearly some of the transactions relate to licenses, PSCs, which have been solely awarded to one party. When in the stage of exploration and discovery, that particular license has reached an important step, then they've looked to farm down or bring in new partners. So, for example, the bottom deal there, the E&I QP deal in Block 1, E&I has made a sizable discovery in Block 1. They have their development plan. That's the right strategic point to bring in a partner to help fund the development work that will happen. We can also see in the Talos deal, the second one there, a number of drilling prospects have been identified. And again, that seemed the right stage to bring in a partner to join the consortium. I think we can also see that there are a mix of players involved in this activity. So you've got majors and giant oil and gas companies involved, but you've also got some of the smaller players, and with Vista, even a private equity-backed vehicle. So there's a range of actors involved in this market. And whilst that's a relatively small sample at this stage to take much from, we think those kind of drivers are going to continue to push deal activity. We know that there are various deals ongoing at the moment, so sale processes are happening, and we think this will continue. Given that it seems unlikely that new acreage is going to be put up for bids anytime soon, we think companies that hold the current acreage are probably going to continue to explore, and hopefully that's going to drive further deal activity. Just to look at another sort of means for private A&D activity, what we were seeing a few years ago was direct transactions with Pemex. So these were not the awards of new licenses or PSCs. Instead, these were private deals just with Pemex. As you can see, here are the examples. This is largely stopped now, and I think as a result of liberalisation slowing down, at least in the short term, it's unlikely that we'll see more of these. So if we turn to some of the fundamentals to the Mexican regime and how that govern how deals are done and things that you need to have in mind when doing deals, there's a variety of sources of law that will influence the sale process. And we've set those out here on the slide. So you've got national laws. You have for each award of a license or a PSC, a particular set of bidding rules that apply to that round. Same for the partnership guidelines, which sort of influence and give criteria for who can form part of the group that are in that license or PSC. And then you have the particular terms of the contract itself. So the license or the PSC, they will regulate how transfers can be carried out. And so all of this is important because this will tell you from these variety of sources what consents you will need from the government and regulators in Mexico, the process for obtaining those, and other requirements in properly transferring your interest, and then what requirements an incoming purchaser may need to meet. And what have we learned from our experience of looking at these things? Well, I think it's important that you review these on a case-by-case basis. What we've seen is for each of the bid rounds, they have changed. And so we're not quite yet at a cookie-cutter stage of doing deals. Each one is an individual standalone deal and set of rules applying to that deal that you need to look at each time afresh. We've also seen inconsistencies between each of these, and that creates challenges in identifying with precise clarity how the transfer process should work. Now, when coupled with the fact that there really isn't a standard practical process in Mexico yet for carrying out these transfers, that creates the potential for confusion. So our response to that has been, you need to be clear in your sale documentation about how you're going to deal with this. You need to build in flexibility. And then one of the things that we've seen done is at an early stage in a transaction, if there is any doubt, there's the opportunity to go and speak to the regulators, to present to them, here's how we think the transfer process should work, and get their sign-off on that. And that can help to remove some doubts. Then, continuing with the fundamentals, who from the government will you be dealing with when you're in the process of doing deals? Set out on the slide here, all of the regulators that touch on upstream activities. Now, they cover a range of requirements, right from the award of the PSC or the license all the way down to issuing permits and things for carrying out particular activities. In the context of deal doing in the upstream world, the most significant actor is the one at the top. So CNH, the National Hydrocarbons Commission, and they are responsible for managing and administering the government approval process and for putting in place all the documents required to transfer title. So that's the main person that you will be dealing with. Our experience of them is that I think it's still early days. As I've said, there's no real set practice for deal doing, so they're still getting to grips with it just as much as the companies are that are trying to effect these transfers. There aren't clear set procedures in place, and as we showed on that earlier slide, in terms of the deals that have been done, they can be very slow in providing their consents. They are starting to provide those consents, so that's good news, but it is not a quick process. So patience is required, and that's something that you need to factor into your sale process and your transaction documents, because it is tough to move things quickly. And then lastly, on these kind of fundamentals, it's important to understand what it is you're actually buying or selling. And as I've said, that's the interest in the concession. Now, in Mexico, there are 4 types of potential contract concession. I'm not going to get into the weeds of all the details of those, but you can see them on the slides and read further there. Really, we need to concentrate on this first slide because it's only PSCs, so production sharing contracts, and licenses that have been granted so far in the process. And so the other 2 examples on the slide behind, whilst there is the potential for those to be awarded, and it's the Ministry of Energy that decides in each bid round what it will use, we haven't seen those employed as yet, and it seems unlikely that we'll see them used anytime soon. So going back to the PSC and the license, licenses have predominantly been used so far, so 76 of those have been awarded, compared with 35 PSCs. The basic rule of thumb seems to be that licenses have been used in bid rounds concerning acreage in deep water and onshore, and PSCs have been used in shallow water bid rounds. Now, for the purposes of doing your diligence and actually understanding what you're buying, it's very important to look at the PSC and the license and understand the differences between them. But when it comes to actual deal doing, there isn't really much of a contrast. The same approvals and transfers that you will need to obtain in order to properly effect your transfer are the same for both regimes. So there's very little practical difference between the 2 in that sense. Right.
And so I will start by saying I don't think my accent is strange at all. But what does all of that mean, what Adam has been describing in terms of the nuts and bolts of actually getting deals done? What have we been seeing, and what are the issues that parties have been grappling with when negotiating their sale documentation? Kind of at the very highest level, and probably obviously for many of the people in the room, it needs to be a Mexican company that holds these interests. So if you don't have a Mexican subsidiary, you need to incorporate one in order to participate in country. In some jurisdictions, incorporating a company is a one-day task. In some jurisdictions, it is not and takes longer. Mexico falls into the latter category, so it needs to be something that is factored into your process if you're not currently engaged in country. And then actually, a number of these other things that we've seen are not commercial issues that people are grappling with in getting their deal done. They're actually about how do we wrap our sales process around the regulatory regime that Adam has described and some of the uncertainties that go with it. So just to take a number of these, so the PSCs themselves, the licenses themselves, take slightly different formats depending on whether the current contractor party makeup is a sole company or whether it is a consortium. And so that in itself creates a degree of complexity when thinking about how is a new party going to come onto that license or PSC. There are also a couple of forms of credit support and security that sit around your obligations as a company under the PSC. That is not uncommon. That happens in jurisdictions all around the world. But in Mexico, there are kind of a combination of them that is relatively unusual. You do see it in some other places. So not only is your interest in the PSC as an oil company underpinned by a parent company guarantee, but there is also a letter of credit called a performance guarantee that sits behind your obligations for the minimum work that needs to be undertaken under that license or PSC. Working out how to unravel that as part of a sale process is, again, not entirely straightforward because C&H requires that on every piece of paper, the exact makeup of the consortia is reflected accurately. So things that you think should be able to stay in place, for example, the letter of credit, with then back-to-back letters of credit provided between members of the consortia, actually doesn't work in the way that it does in other jurisdictions. The fundamental letter of credit needs to be withdrawn and replaced, and even though it's in the same amount, just to show the new identities of the particular companies that make up the consortia once the deal is done. Transfer of title is also not as straightforward as it is in a number of other jurisdictions. There are a number of steps that you need to go through in order to ultimately transfer title from one company to another. Kind of the headline steps of that are just noted there on the slide. And the final step that ultimately transfers title from one company to another is an amendment to the PSC or the license that needs to be signed by both C&H and the existing members to the license. So what does that mean? Well, it means that in every deal that you do, regardless of whether technically you need the consent of your co-venturers or C&H, and I'll come on to both of those in just a moment, you effectively need their consent because you need them to turn up and sign the actual document that is going to transfer title. And so building that into your sale documentation, and as I'll come on to talk about in your JOA, are important considerations in thinking about how to get your deal done. So I mentioned briefly when is C&H consent required on a transaction. For those of you that are accustomed to doing deals in jurisdictions around the world, you will know that it is not uncommon for all asset deals for the government to give its consent in order for the transaction to take place. And in most, but not all, jurisdictions, for a change of control or for a share deal to take place, you also need the regulator or the government's consent. That is also the case in Mexico. But in Mexico, there is kind of one nuance to it that we haven't seen in jurisdictions elsewhere, which is this concept of a change of administrative, let me just get the terminology exactly right, of corporate or administrative control. That is kind of a nuanced concept when you are talking about joint ventures. And so it is not been entirely clear from C&H yet, what do they mean by that? So if you are, for example, a minority participant under a PSC holding, say, a 20% interest, and you want to transfer that 20% interest, does that mean that when you've sold that 20% interest, that has resulted in a change of corporate or administrative control of the contract as a whole? Query whether it has or hasn't. And we've had slightly different opinions coming out of C&H as to what that means. And so working through the sources of law that Adam mentioned earlier, we think this table kind of neatly summarizes where you get to. And actually where you get to is for almost any type of transaction, whether expressly or not, you are going to need C&H's consent. Not least of which, because they need to sign a document at the end that is going to transfer title to the interest. So whether express or not, we think that is the place you get to. And so what you need is good counsel in Mexico who have that relationship with CNH who can go and speak to them to say, hey, this is what we're thinking about. Can you work with us in order to facilitate getting this transaction done? And then a few other things just to be aware of in terms of getting deals done. Competition approval, which is not something that you always think about in the context of upstream deals because it's often irrelevant because there are so many players. The thresholds for triggering competition approval in Mexico are actually quite low. And so a number of the transactions that we've been involved in have been triggering the need to go and get competition approval. Something to have in mind because that's relatively uncommon in the upstream space. Partner consents I've touched on, and the thing to think about in that context is really your JOA. So JOAs, as you know, will often have express consent rights or preemption rights or rights of first offer or things of that nature in favour of the co-venturers in respect of an asset. In Mexico, because those co-venturers need to sign up to various documents in order to facilitate a transaction, what you don't want is to have inadvertently provided them with another consent right by virtue of the fact that they need to do that. So in order to legislate for what your partners are and are not allowed to have in terms of consent over your transaction, that is something to build into your JOAs to say either they do have a consent right or they don't have a consent right, and what that means, JOA partners, is that you are compelled to sign the documents that you need to sign if I want to go and sell my interest. And then the final point, Adam touched on briefly around governing law and dispute resolution. We are seeing English law pretty commonly in Mexico. We have a vested interest in making sure we see as much English law in deals as possible, so we'll continue to emphasise that. We have also seen Texas law and New York law used in the context of both joint bidding agreements, sale and purchase agreements, JOAs, etc. So there is a mix. And so we thought it would be worth just spending a few seconds pausing on this slide just to mention that there are cultural differences in the way English law style deals and US law style deals are done. Most of those things do not go to the fundamentals of purchase price, structure of the deal, etc. But what they do go to are some of the more technical legal items that sit in your sale and purchase agreements. I won't recite them there, but it is worth having these things in mind, because what we have seen in a number of transactions is people, especially the lawyers, getting quite worked up about what they see as the legal issues and the legal items that they're responsible for, which are actually just a result of cultural differences in the way deals get done under those two styles of document. That doesn't mean that one side or the other needs to roll over on their particular point of view, but it is at least worth understanding where those differences are actual commercial differences and where they are just stylistic differences in how deals get done. And then the final point that we wanted to touch on around kind of the deal doing aspect of things is what is the impact on financing? Now, clearly for super majors and very large independents, they will finance transactions in the way they finance everything else, either off balance sheet or through normal corporate facilities. But for small or medium-sized companies, kind of the key takeaways in respect of financing is that international style reserve-based lending, the way a lot of the industry works in terms of raising debt, is available and does work in Mexico. So we acted with Manuel on the first one that closed recently. And I think the important things to say about it is, one, it worked. So it was possible to get lenders on board and comfortable with the Mexican regime and how it works. So debt is available to finance acquisitions. And secondly, that it happened in the context post AMLO's election. And so although we've heard a number of things around the challenges of the change in regime in Mexico, even in that context, financings were able to be done, including getting on board the various regulators that needed to approve the financing. So things to think about from a lender perspective in financings. What will be relatively uncommon to at least a number of you who are more familiar with the US regime. In most international regimes, including in Mexico, it is not the investors that own the hydrocarbons under the ground. It is the state that owns those until they come above ground and are produced. And it's only at that point in time that title transfers across to the oil company. On a change of control of the company that owns the asset, that requires government consent. That is clearly a lender risk. So if a lender was to want to enforce its security, that is subject to government consent. And then finally, there are a relatively wide number of termination rights in favour of the state in the PSCs and licences. Termination rights, full stop, are pretty common in PSCs and licences in jurisdictions all around the world. In the Mexican ones, they're probably slightly wider than we would typically see, but notwithstanding that, the lenders were able to get comfortable and lend in respect of the first financing that closed relatively recently, actually just a few weeks ago. So in terms of kind of the final piece of financing and what security package is available to lenders doing upstream deals in Mexico, Manuel, I'm just going to mention briefly what that security package can look like.
Yeah, there's obviously some securities that, because of the structure, are not allowed or not available in Mexico for this type of projects. So the most common, or what we think are the possible, the best options as to security package is first the pledge over the 100% of the shares of the company. This may have some, not restrictions as to the contract. You will be free to have this agreement and pledge the shares without the prior approval of the government. However, something that is important to consider is that you need, or we strongly recommend including the pledge agreement, a section whereby the parties agree to work together in order to obtain the prior consent of the CNH in the event of an enforcement. Because again, as Darren mentioned, change of control of the company requires approval. So if you have a pledge agreement, you cannot enforce the agreement without the prior approval of the CNH. So that's a big condition that must be included in the pledge over the shares. Another guarantee is pledge on other types, for example, of accounts or bank accounts where the money of the collections rights are deposited. We don't mention this in the slide, but instead of this pledge over accounts, we can have this figure, which is the trust, the financial trust in Mexico, where for the collection rights, so where all the collection rights are placed in this trust, managed by a bank license in Mexico, and then under the trust agreement, the bank will distribute the proceeds, typically to the operator or whoever has the rights of the proceeds until there's a breach of the agreement or of the loan document, and then it will distribute those proceeds to the lender. Then there's a couple of other options for...
Yeah, and one of the main instruments that we had to make this doable was a pledge over the rights that the operator has in the license or PSC, and that required a CNH consent. This one is particularly important, and there were a lot of doubts in the industry, and people that normally do financing in Mexico, they didn't, the expectation was too low to materialize this. We showed this doable. We worked together with CNH in a well-defined plan. It was possible to obtain that consent in less than 1 month. Deliverables to CNH were all acceptable for the financing institutions, for the lenders, and it worked pretty well. This case in which we work together is being actually used now as the, let's say, the procedure, the mechanics in case others RBLs in Mexico want to be implemented. And this instrument allows you to pretty much take over proposing as lender a new operator that satisfy pre-qualification conditions of the bid. The rule to select that other operator are clear from the beginning. The same were established to be awarded with a contract. And that's something I would say new in this context. No, there are others important, of course, like having an assignment or a security over the key insurances of the project. And one of the relevant limitations is that you cannot establish a mortgage or similar lien over real estate or materials that are acquired for the project, which is normal considering that the state want to have control and continuity of those assets, either used by you or a replacing operator, no? And that's the main characteristics of the Mexican security package in this context.
Okay, so now Jeff will talk about the anti-corruption terms in Mexico and the U.S.
Very good. Thanks, Manuel. So your final strange accent of the day. We've gone from the UK to Mexico City to East Texas. So I want to talk a little bit about, FCPA and anti-corruption enforcement in Mexico. Is that better? Because I think if you're going to do foreign business, particularly in a locale that's gotten some attention from the U.S. government, particularly in the last several years, you want to kind of evaluate the risk and know what you should and your employees shouldn't be doing in those areas. So I did a little bit of research, and from 2009 to 2018, the U.S. government has identified and prosecuted or some other type of enforcement action. It identified the locations of the improper payments in those prosecutions. So Mexico was number 4 on the list behind China, Gabon, and Brazil. So if you have operations or employees working in Mexico, you're certainly in a high-risk area, for at least for the U.S. government's perspective. The FCPA, which is the Foreign Corrupt Practices Act, and I suspect most people in the room have some working knowledge of what that is and what you can and can't do. If you do not, I'll give you my card after we finish speaking, because we may need to talk further at some point. But in any event, the regulations, the statute is enforced in the U.S. by primarily 2 different agencies. The Department of Justice prosecutes the criminal aspect, and the Securities and Exchange Commission, the SEC, prosecutes or enforces the civil aspects of the statute. So under the FCPA, we have what are referred to as the anti-bribery provisions. The general prohibition is that you cannot make a payment of money or provide anything of value to a foreign government official. In its most basic sense, excuse me, that's what it boils down to. Now, typically what we see in FCPA cases, probably in 77% of the enforcement actions that are pursued by the United States, the offender used some type of third-party intermediary. That's what tends to get people in trouble. It's an agent, a distributor, a joint venture partner, something of that nature. The statute applies to, excuse me, issuers. If your company's stock is traded on a U.S. exchange, this is probably a little bit beyond the scope of this discussion, but if you look at the top 10 FCPA settlements to date, there's only one U.S. company that's currently on the list. They've mostly been foreign companies because they fall in the jurisdiction of the U.S. Statute based on their status as an issuer, that the government can reach them. You typically need a U.S. nexus to fall under the statute. Again, if you're an issuer, if you're a domestic concern, which is defined under the statute as a U.S. company, if your company is incorporated anywhere in the U.S., the statute follows your operations wherever you are. And certain persons and entities, if they engage in conduct while in the U.S. So if you have a foreign employee who's visiting Houston, he or she sends an email in furtherance of a bribery scheme while they're here just for a short period of time working, that will be sufficient, at least from the government's point of view, to bring you within the scope of the statute. The other broad subject area of the FCPA, what are referred to as the accounting provisions, are often referred to as either the books and records provision or the internal controls provision. And under the books and records provision, an issuer is required to make and keep books and records that are reasonable in detail so that an investor can look and see how the company is allocating or using its assets. Now, typically in enforcement actions, they tend to be one or the other, although some companies have gotten themselves in positions where they have been prosecuted for both. But usually it's one track or the other. I was a prosecutor for a long time. I have yet to see a company record an improper payment as a bribe, because that would get you in trouble under the anti-bribery provisions. But they typically should refer to it as some type of consulting fee or for services provided. But if that's not accurate, and once that's recorded in the books and records, you can face FCPA liability for that. So I wanted to touch briefly, I think they're probably in the handout. I won't go into them in a lot of detail. We kind of included some Mexico-related FCPA investigations. And again, when I did some research, going back about 10 years, there have been at least 54 U.S.-driven enforcement actions where Mexico was at least one of the countries involved in bribe payments. We have Key Energy, which was Houston-based. This has since settled. I think they ultimately ended up paying the government about $5 million to settle it civilly. They were not prosecuted criminally. Most people have probably heard about the Walmart investigation that's been going on for almost 7 years now. And I think one of the large takeaways from that, if your company gets involved in an FCPA violation, it's going to take a lot of time to resolve it. And what these stats, the 54 enforcement actions, doesn't capture, it doesn't capture companies where, for example, they're private, they're not publicly traded, they get involved in an enforcement action, they never get prosecuted, so it never becomes public. There are a lot of companies out there that fall into that bucket. You also have a lot of folks that have internally discovered some type of corruption issue. They hire a law firm to come in, do an internal investigation, write a report, hopefully remediate and fix the problem. And if they don't voluntarily self-disclose that problem, and the government never finds out, those companies that fall into that bucket aren't captured by the stats. So my point is, there are a lot of ways that a company can get into trouble and have to suffer through a lot of disruption, legal, third-party vendor expenses to handle one of these things. So it's really worth the risk analysis for your company and train your employees as to what they should and shouldn't be doing and what red flags they should look out for. A few more cases that are also Mexico-related. Biomet, which is also since settled. I think the settlement value on that one all combined was about $13 million. These are some of the smaller FCPA settlements. There are much larger ones out there, but they tend to be some of the larger super majors and larger international companies involved. So these slides are just meant to give you some idea of the companies that have run afoul of the U.S. government in this aspect and how it can affect their operations, their reputation, and things of that nature. Again, we have a few more. I think probably the one that probably stands out most on this was the Siemens settlement, which was $800 million, which was number one on the list for a long time. It is no longer number one, but allegedly, and they actually pled to it, they paid over $2.6 million in bribes to a consultant in Mexico, some of which was passed on to a senior Pemex official. And I think the biggest takeaway from that is it drives home the point that you really have to stay on top of your consultants, do your due diligence on who you're hiring to represent your company. And also, many times we don't think about it because we have kind of a different corporate worldview here in the U.S., but the payments to a foreign government official is what brings you into the scope of the FCPA. But you have to keep in mind that if you're an employee of a state-owned or controlled entity, those people are foreign government officials. So if they're employed by Pemex or PDVSA in Venezuela or Sonangol, Angola, bribes or things of value paid to those folks to obtain business or secure an improper advantage would be violations of the FCPA if the government can prove that happened. I want to shift and talk briefly about some of the anti-corruption regime from Mexico. I think historically, anti-corruption has been under-enforced in Mexico, but under the more recent regimes and new laws have been passed, I think that environment is changing. That's true in a lot of places around the world. The U.S. and other countries have had a lot of success in pursuing anti-bribery investigations and have gotten a lot of revenue from doing so. So I think other countries are trying to see that they can also get involved and maybe clean up their business environments for all parties involved. So if you have operations in Mexico, you need to be aware that corrupt conduct cannot just bring U.S. scrutiny, it could also bring scrutiny from the Mexican government. The federal criminal code in Mexico criminalizes both the person offering the bribe and receiving the bribe, which is actually broader than the FCPA. The FCPA only penalizes the bribe payer. The bribe receiver does not fall within the scope of the statute. Now, there are other U.S. statutes where the government can reach a person receiving the bribe. Sometimes those folks are prosecuted under a statute called the Travel Act, or they can just be prosecuted under wire fraud or money laundering statutes. So they're not completely out of the scope of the statute, out of the scope of the government, but just of the FCPA. The Mexican code is actually broader in that it criminalizes both sides of a corrupt transaction. Most recently, it was enacted in 2015, or began in 2015. The law was enacted in 2017, and more recently, we've read and seen reports of a more robust implementation of something that's called the National Anti-Corruption System, where the Mexican Congress and the majority of the state legislatures have approved comprehensive legislation to combat corrupt activity. These reforms include enhanced investigative and audit authority, additional sanctions for corporations and individuals, which is sounding more and more like kind of the approach the U.S. is taking and has taken for several years on the FCPA front. New prosecutor had been appointed to be the first chief anti-corruption prosecutor. And I just think it just kind of drives home the point that if you're going to operate internationally, particularly currently in Mexico, the risk of you being, if your company is engaged or an agent on your behalf is engaged in any questionable conduct, the risk of it being discovered is increasing, and the risk of it being prosecuted or investigated is increasing, which causes a lot of problems for your company. I think the biggest takeaway, whether it's Mexico or elsewhere, you need to do the due diligence that you need to as you engage in these deals, or you make acquisitions, because under the FCPA, you can acquire a company that has a problem or an operation that has a problem, and you thereby acquire the FCPA issue that you have to ultimately deal with.
Okay, so just for this last section, we thought we would have a bit of a Q&A forum and give you the opportunity to ask some questions if you have any. I'm conscious that sitting in that sort of environment often doesn't encourage people to sit and ask questions. So to get things started, I will ask the first question of you guys, and then open up to those in the audience. So when AMLO was elected, there was clearly some angst and nervousness in the industry about the impact that he might have on the oil and gas business. We're now 3-6 months along. Do you think that nervousness has been justified, or are there reasons for optimism about how things are playing out in Mexico?
I think it depends on the angle. If you are on the business development, it's clear that the bidding program was stopped, and that there's still one there that they're postponing, but the message is that it's going to be canceled. And it's going to be transferred to a different scheme of a service contract. Pemex is already working on that. That will be launched in June. So from that perspective, I think it's justified that fear. But others, projects that are performing, approvals are obtained from regulators. Actually, regulators have an aligned interest because they are also on probation. If they don't work and projects don't work, they are also out. So what we have faced in practice is that a lot of approvals of development plans, budget, programs, wells, etc., it's actually faster with them. They are enticed to move together with you. So on that side, we believe that opportunities are there, and the secondary market, it's clear that it's a reality now. farm outs. Last week, one change of operator was approved at Senate level. So, I mean, it's going, no? I don't know what you think.
No, I agree. I think there are positives and negatives. Negatives, of course, the big one was the cancellation of the airport that we already mentioned, a project that, was already an investment of, I think, $3 or $4 billion. And because Lopez Obrador decided that he didn't like the project, or he argued that there was a lot of corruption and it was built on a lake, they needed to cancel the project, even though it was more expensive to cancel that project than to terminate it. Now, Mexico City keep the old airport, and they're building or expanding on a small airport in the north of the part of the city. So I think that first action that actually was taken before he took office. Lopez Obrador took office on December of last year, but he really took office the day that when he won the election. It was July of last year. So he governed de facto for 6 months, and during that term is when he started doing these things, these threats. So put a lot of pressure or nervousness in the market. The Mexico peso went from 18 pesos to 21 or 22 pesos per dollar. But since then, now the peso start going back to the 18, 19 mark. So again, this airport, I think, was the biggest footprint or biggest statement, and I think was more to say, I'm the boss here, I don't care, and this now the things are going to do my way. So other things that have been, making nervous the people, but at the end, there's also some weights that have put him like a break. For example, he wanted to create a National Guard, fully military, instead of the policeman, with a control by the army, and then the Senate, which is pretty much controlled by him, saying no, we are not going to allow that. We're going to put like a civil, still the National Guard, but a civil head of the guard. He announced this suspension of the rounds, and which obviously is important because he has been somehow criticizing the energy reform, and he said, okay, for now the rounds are suspended. But his business advisor, who has a strong voice on him, he just mentioned to the U.S. Chamber of Commerce last week that the suspension is just provisional, that if the agreements show, or all these contracts show that there's a successful, the rounds will be back sooner rather than later. So again, I think we're seeing some positive and negative news even the same day. As Manuel mentioned, the day that the refinery was announced, a few hours ago, the subsecretary of the Ministry of Finance announced in London that they were not going to build a refinery, and they were going to use that money to improve Pemex. So everybody was saying, well, that's a great measure, it's very reasonable. And then 2 hours later, Lopez Obrador said, no, we're going with it, with the refinery, we're going to spend billions of dollars with the refinery. But again, so there's some things that I think we need to take here positive, and again, I think the Mexican government is going to realize that they need a lot of investment, that there's no enough money in the government or in Pemex or capabilities to continue this energy reform. So we will see.
So just to follow up on that, so you mentioned Pemex a couple of times. What's their reaction been as AMLO has, he said a lot about them over the last few months, and clearly wants, from my perspective at least, what I've been reading, he seems to be wanting to direct focus from kind of our audience here, international investors, back to Pemex being more of a national champion. What has their reaction been?
I think now in this short period, they are somehow overwhelmed and a bit disorganized internally. The CEO of Pemex doesn't have an industry background, as everybody knows, and the perception is that the show is run directly by the president, who is taking the relevant decisions. But there are others on a daily basis that somehow are, again, disorganized. There are departments in Pemex that months ago were working to show the benefits, for example, to migrate some entitlements to CNH contracts and made a whole analysis of the benefit of doing that. And from that one day to the other, the instruction was precisely the opposite. So that's something that has the people a bit confused. They have a lot of pressure because of the target of the 2.6 million barrels. It's something that it's going to be extremely hard for Pemex. And in this conference, they will need to explain why and then what's next. And that's the bet, that when they reach that point, we'll go back to the bids, Other things that are happening is a lack of direction. There's a lot of people in Pemex, extremely talented, experienced in shallow waters, which is the main of Pemex. However, they designated the director for Pemex Exploration and Production. Then it was supposedly removed because of an investigation of this nature that Jeff was talking about. And then suddenly today, there's a strong rumor that he has cleared any question, and it seems that he's going to be back. So that type of messages have confused a lot the industry. For everybody knows that it's probably a fight between the CEO of Pemex and the head of the Ministry of Energy, trying to show who has more power in front of his boss. And both of them were criticized because of the poor planning for the anti-robbery, gasoline anti-robbery plan. So that's the environment Pemex is having. It's clear they will need a lot of help. The traditional way of awarding contracts is back as to service companies. They assigned just in January and February a huge budget that, by the way, is debt for Pemex, for companies that are more local and might be some things of due diligence and background check to do in terms of who is handling those contracts. So that's, I would say, in general terms, Pemex condition now.
Any questions from the audience? Anything we haven't touched on today that people would like to ask, or follow-up questions for us to expand on? Okay, well, maybe I'll just wrap up with one final question then. So kind of the perennial end of presentation question, like, what does the future hold? What do you think the next 2 to 3 years, say, looks like for the sector in Mexico?
I think opportunities as to secondary market, it's fundamental to follow up on that. And I'm seeing that because there are projects that have already proved commerciality, so they're jumping to production with a field development plan approved, and in the short term, they are reaching some important targets as to production. Others that are now in exploration stage and are showing investment, real investment. So that's an important thing to follow. As a strategy, I think there is time to do few recommendations, like let's focus on performing. Let's show that what we have, what we were already awarded, it has a lot of value to give. And then in 2-3 years, when they realize all these fundamental mistakes, and at the same time, you are showing that real investment was done, production increased by private operators, etc., we will need to align agendas, not to show he was wrong, but to show how we can reach the same goals, which are their goals. We're not changing his plan. We are just supplementing his plan. And I think that's a completely different approach. We are not recommending to take the position that this is extremely wrong and the Mexican government is wrong and we would be doing this differently. No, let's show them that we are making their plans happening together. No, So it's listening carefully and implement based on that. Mexico is focusing attention on Tabasco, Campeche. There is where the budget is going to be placed, onshore and offshore. There are other areas that they are not planning for the moment to do something. When they retake the bidding program, it's an opportunity. Take advantage of this year and next year. I mean, CNH is working regularly. Of the 7 commissioners, quorum needs at least 4. We have those 4. It's not the case of the Mexican FERC. I mean, the CRE now is without quorum. And we will have, unless something happens, but we will have that quorum at least up to the end of next year. So hurry up on your approvals, unless people change in the regulators, and it's something that may happen.
Okay. Any questions? Okay. Well, thank you very much for coming today. I hope you enjoyed the presentation.